Hi, I'm disability lawyer David Brannon. In this video, I'm going to take you through what to expect at a Social Security Tribunal hearing for a CPP disability case. So after watching this video, you'll have a better sense of what happens in these hearings, what you can expect, and so it'll hopefully take some pressure off if you have one of these things coming up. Now, if you like this video, don't forget to hit that like button, leave us some comments, hit the subscribe and bell notification as we send these videos out a few times a week. So we often are asked what happens at the Social Security Tribunal hearings. There's a lot of uncertainty around them. There's not a lot of information necessarily online to learn what do these things look like, what happens, this kind of thing. And I want to take you through what these hearings look like. So what do these hearings look like? Well, they are 90 minutes usually, so an hour and a half. They are done by teleconference, in person, or by video conference. Video conference is now the most common way that these hearings happen, and they use the Zoom platform, which is fantastic. In-person hearings have been very rare, and I've done dozens and dozens and dozens. I probably can count on one hand how many in-person hearings I've done over the last 5 years. Most people do not prefer to do them in person, and it makes a lot more sense to do them by phone or even by Zoom is now the preferred method of doing these hearings. What these hearings are, so you show up to these hearings, we'll go through on Zoom because that's the most common way. So you show up, you will be emailed by your representative or through the Social Security Tribunal will email you the Zoom links. You log in to the hearing. The first 15 to 20 minutes is taken up with the judge kind of giving the lay of the land, welcoming everybody, explaining what will happen, explaining the law a little bit, saying that here's the standards that I have to meet, here's what's going to be expected. Now, I've always been there as a representative, so I'm not sure if they change what they say if you're just there yourself without a representative. I'm not 100% sure. I'm expecting they might go a little more in detail. But anyway, they will lay out the basic rules. They will, if you have someone else there, they'll ask them to leave the room, that you have to be so if you're doing this on Zoom, you need to be in a room where it's just you with good lighting, where you can hear, that kind of thing, right? Now with Zoom, you can either phone in and still see the video, or you can just talk through the computer. So you want to make sure it's going to work. So the next thing they'll do is they will make sure that everyone, before we get started, has everyone got a copy of the hearing file. You're going to hear about this thing called a hearing file. And all that is the official document record for your case. So the hearing record would include everything sent over by Service Canada, any submissions and new documents that you've sent in, those all get stamped and sent back out to you as the official hearing record with little stamps on the bottom with page numbers and all this kind of stuff. So you need to have that in front of you. I prefer to always have it in a paper copy just because of I don't want any crashes or any problems. So I always have a paper copy, and we always produce a paper copy and courier it out to our clients, no matter where they are in the country. So you have that in front of you during the hearing because it's very important because people are going to be referencing it, okay? So once they confirm that you have that, they will say, is there any other questions or preliminary things? I usually say a few things, but you don't necessarily have to say anything. Then what they will say is, okay, well, we're going to get ready to get started. I'm going to swear you in, or get you to affirm. They will ask you to affirm you're going to tell the truth. You just have to say, yes, I will, kind of thing. And then now you are under oath. So any lies that you make after this point are perjury, and you can be, it's a crime kind of thing. So that is important. They will put you under oath, and then they will move forward. So what they will usually say is, okay, now let's go. So when you're there with a representative, this is where I would step in and say, all right, I'd like to make my opening statements, and I'll say some opening things. Usually in my opening statements, what I like to do is confirm. I want to preset the decision maker, the judge, to know exactly what's coming. There's a lot of psychological studies on this that it's much more effective as a presentation, and it's easier for the person receiving the information if you give them a structure and to which they can receive the information that's coming at them. So you don't want to just start downloading information at them and that's coming at them. They have to try to think, what is this important? Do I need to know about this? What you want to give a framework and a structure ahead of time. So I will say, here are the things we're going to start with. We're going to start by going through this, and I usually say the work history. Then we're going to move on to this, and then we're going to touch on these issues, which I think are critical. And what I do is I focus on the things and the red flags that I anticipate that are going to be the biggest questions for this judge. And you can often see a lot of relief out of the judge. Okay, thank you. You're not just going to ramble on for, 80 of the 90 minutes or however long you got on irrelevant things. And then I got to try to get all the stuff I want to know about in the last 10 minutes kind of thing. So I let them know up front. And sometimes the judge will say, yeah, and I also want to know about whatever. So I immediately write that down. Okay. And I will say, is there any other things that you really want to make sure you hear about in this hearing? And they sometimes tell you, yeah, I want to know about what about that psychology? What's the status of that? So I would write that down. We're not going to get into it right now, but I write it down. Then what we do is I use the method called signposting with my clients to make it easier. Because what'll happen next is you need to start telling your information and making your presentation. Now, if you're there with the representative, it's easy because the representative will lead you through it, through questioning. Just like you see sometimes in a court case where they're questioning the witness on this, it's the same kind of thing. Now, I make it even better for the clients and I prepare them ahead of time, say, look, we're going to use signposting. I'm going to tell you the topic we're going to talk about, and you are not to deviate from that topic. And if you start to, I also remind you that, well, wait a minute, we're talking about this topic now. Extremely important. When you get there, you're going to be nervous. And then what nervous people do is I ask them, let's go through your job history. What was the first job you have? And people can go from the first job they have to what's going on now, to the doctor said this, and I really want to work, but I can't. And that is a disaster. When you get nervous and just keep talking and try to, you're crossing all these different things, you need to compartmentalize it, talk about specific things, and then move through in a logical fashion. Otherwise, the judge, they're not going to be able to take things in. You're going to be all over the place. It's going to be hard for them to make sense of what's important. So I use a signposting. So I will tell the client, we're going to start with talking your work history, and we're going to focus on that. So we'll move on to other things later, but let's start with your work history. That's exactly what I would say. So I'd say, tell me about your first job that you had starting back in whatever year, and we're going to come forward. That way, if my client goes on a tangent, I can reel them back in, and the judge will usually be fine with it because I've already set the parameters. If you're doing this yourself, you're going to have to really try to be disciplined here. You can't go in and do a rambling thing where you start here and go there. You got to approach it in chunks. You're going to touch on this topic, then you're going to move to this topic, then you're going to move to that topic, and the next one. The topics you are going to cover are going to be different in every case because you're going to cover what are the key issues in your case and the key red flags from the perspective of the decision maker. So once you go through all of those things, what I always do is at the end of each topic area, I pause and I ask the judge, is there anything else you would like to ask on this before we move on? And they often will. And in fact, usually in the beginning, I tell them, please interrupt at any point to ask any types of questions during the questioning. Don't save them all to the end. It's easier if the judge interjects and asks questions and clarifications while you're going through. So after each topic area, so if I say we're going to move on to talking about what went on medically in the year up to when the minimum qualifying period ended. That's a very important topic for almost every case. I will say now we're going to move to that year, and I will then take the client through it, and I'll ask the judge if they didn't ask anything during it. I'll say, do you have any questions about any of this before we move on to the next thing? And often they will. Now this results in a very structured, easily to digest and understand presentation, which is super important. Once you go through that, you're going to tell your story usually you will testify first and you'll bring in witnesses afterwards when you're done. That's usually how the judge will want to do it. In rare cases, we might bring a witness in first if it's the only time they can do or some other kind of thing like that. But generally, you'll bring the witnesses in next, and the witnesses cannot be there listening to what you're saying. They have to come in independently. That's easy to do if it's by Zoom because they're just not there. But if they're in your own household, you have to make sure they're outside of earshot, not listening at the door kind of thing. Because if there's any sense that they've been listening and they're trying to tailor what they say to what you say, you're going to lose all credibility and may result in a loss in your case where it shouldn't. The judge will ask questions. This is the type of thing where we encourage the judge to interact and ask questions. And this will go on. Usually when there's about 15 minutes to 15 minutes left, I will usually say, okay, I'm at the end of my presentation. I do have some closing statements, and I'll leave it to the judge to say, is there any other questions you want to ask before I get into my closing statements? And they usually have a bunch of things, okay? I've tried to anticipate, and I've asked them ahead of time what their issues are, but things might have come up, and maybe they wrote notes and they didn't ask about it. And so they will ask a bunch of questions at the end, and you should do your best just to respond as best you can. There's no standard questions that they ask at the end. But they're going to want to know things really the things they want to know about are any updates with medical, Your responses to any of the red flags that they've identified, like if they've for a big one would be is if you left treatment early or you refuse some type of treatment, they're really going to need you to comment on that and either admit that it was wrong is the ideal thing, and here's what I've done to make it better is the best way to answer that. You can go the bad way and make excuses and this type of thing. They're not going to be really wanting to hear that. So at the end, you're going to do a closing statement. Again, as a representative, what I would be doing is applying, here's what we've heard, here's what the law is, here's why this claim should be approved. And to the extent possible, I don't always try to paint Service Canada as the bad guy. I often say, well, if they had looked at it this way or if they had done this, I try to show how were wrong, maybe because they didn't have all the information or they weren't here to hear this new testimony that they might have even clarified, that's my approach. So you do your closing statement. I do it like 5-10 minutes max. This is not like an hours long statement because you're going to have people asleep, right? You just hit the key points. So I'll have something prepared ahead of time, but I will modify it based on what happened in the hearing, and that I'm always listening to the judge to see what are they asking, because they'll give clues to what their inclinations are, what they're concerned about, and I might modify it. So if I've heard a lot of stuff in the hearing that I'm thinking, wow, this is not exactly how I anticipated, then what I will do is after I'm done asking the questions, I'll say to the judge, could we take a 5-minute break? I just need to compose myself to get ready to do the closing submissions and maybe go to the washroom or something. And they'll be like, sure. They will always say yes to that. So I will take a break and I will rethink what I'm going to say, restructure it, cross out things, and then come back, do the closing, and then we'll leave it at that. The judge at the end will thank everyone. They will say that you should have a decision within 1 to 2 months usually, and that they wish us well, that kind of thing. And then it's just shuts off. I will then personally, what I usually do is get on the phone calling my client afterwards because everybody's super anxious. How did it go? I'll be honest with the client on how I think it went. I say, look, like I've had it go both ways where it seems good and we lose, and other times when I'm sure we lost and we won. So I don't take a whole lot away from the hearings, but usually you can tell if it went well. When I consider it went well is when we got all the information out that we needed. When it doesn't go well is when we wanted to get out all this information and we couldn't, or if something just comes out of left field. I once had a client's husband who wanted to appear. They both insisted it. We practiced with him, and when he got there, he just went off in left field. Like, he was a guy that was smarter than anybody there, and in his own mind, and just completely tanked the whole thing. Be careful with witnesses. And if your lawyer or representative is saying, look, we really don't need this witness, take them on their word. Like, they're there, like, this was not a witness that we needed, and in fact, he came in and tanked the whole thing. This is how lawyers lose cases, by witnesses. You never put a witness up that you don't know what they're going to say, and in this case, I thought I did. But at the end of the day, it's the client's case. If they want to insist that the husband be a witness, then nothing I can really do there. I can't really refuse it. It's your case. So, but just don't think that piling on witnesses is necessarily a good thing. You only bring in a witness if there's a specific reason to have them there. But there you have it. That is what this is going to look like. It's a 90-minute hearing. There's a start, a middle, and an end. That's basically how it goes. And you want to, like I said, you want to really practice ahead of time. You want to go in with a plan, go in with specific things you're going to talk about, have your closing argument already structured out. I don't write it out as a script, but I have it bullet pointed out. Have your opening bullet pointed out and go in with a plan. And that's the way for success in these things. I thank you for watching. Don't forget to like this video if you've enjoyed it. Leave us some comments, and we'll see you back here next time.